like
Yes, to enhance.
with our. It's gonna take me a second. I'll figure it out. Mr. Bell, in cause number 26, DCCR 0139, you're charged with the state jail felony offense of theft of property with previous convictions from September 25th of 2025. The indictment alleges you were previously convicted of theft May 18th of 2018 in 2 cases, and then after that was final December 3rd of 2021. And then the indictment further alleges that you were previously convicted of the state jail felony offense of unauthorized use of a vehicle June 24th of 2019. And after that was final, you were convicted of evading arrest or detention with previous convictions, a state jail felony November 8th of 2021. And after that was final, you were convicted of burglary of a building, a state jail felony, June 26th of 2023. And how do you plead to that charge?
Yes.
And are those, all of those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
And I think. Okay, and then we have. Clause number 26 DCCR 0140. And, sorry, just. And in that case, you're also charged with the state jail felony offense of theft of property with previous convictions. And that one is from December 16th of 2025. The indictment alleges the same prior theft offenses, the 2 from May 18th of 2018, and then the last one from December 3rd of 2021. And then it also alleges those same prior 3 state jail felony convictions. And how do you plead in that case?
Guilty.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are those prior convictions all true?
Yes, ma'am.
And then finally, we have 26 DCCR 0274. And you are charged in that case with evading arrest or detention with previous convictions from January 21st of 2026. It alleges that you were previously convicted of evading arrest or detention March 13th of 2017. And also November 8th of 2021. So this one does not list those other priors, so it just is a state jail.
It's supposed to.
And I apologize. I didn't notice that it didn't list the other priors.
We don't object to an amendment if they.
Now, the state would ask to amend.
I'm not writing all that in.
Okay. You want to dismiss that one?
I mean,
That is the,
evading arrest or detention with previous convictions.
gosh, I hate dismissing and evading.
I mean, I can reset it. Y'all can file an amendment, or if you want to write it out, but that's too much for just an amendment. That's 3 prior
Understand.
offenses. So whatever y'all want to do, y'all want to talk about it for a minute.
I can write them out if I need to be consistent.
Why don't you do either handwritten or typewritten if you want to get down here real quick, a notice of to enhance with those 3 in it. And then I can read the enhancement, the notice to enhance.
Okay, I'll do
Okay.
that very quickly.
I'll hold it.
Thank you.
And then, on Jabar Bell, Mr. Parker.
Just to remind you, you did complete the first two, and the third one you started, we had to do the enhancements.
Okay,
He's already pled guilty, but you're just starting to enhance it.
thank you. And so did it, it's probably not gonna show up. Did you file that through?
I did not, Your Honor. I'm offering it in open court because it was agreed by defense counsel. I've
Okay.
given him an opportunity to review both the motion and the order, which I'll submit to the court at this time.
All right, sir, you're Jabar Bell again, right?
Yes, ma'am.
And so we're back on cause number 26, DCCR 0274. And in that case, Mr. Bell, I'm going to start from the beginning in that one. You're charged with the state jail felony offense of evading arrest or detention with previous convictions from January 21st of 2026. And the indictment alleges you were previously convicted of evading arrest or detention March 13th of 2017, and then again November 8th of 2021. And how do you plead to that charge? And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
Now, Mr. Parker, the state has filed a motion asking to amend the indictment to include those two prior offenses that we've already gone through and read in the other tech cases. Do you have any objections? And you will waive your any time to review that,
Yeah,
correct?
Judge.
So, Mr. Bell, the indictment, I'm going to grant the motion to amend the indictment. Further shows now that you were arrested or convicted previously of unauthorized use of a vehicle, a state jail felony, June 24th of 2019. And after that was final, you were convicted of burglary of a building, a state jail felony, June 26th of 2023. And are those prior convictions true?
Yes, ma'am.
And in all three of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
Objection?
It's admitted in each case. Is there any evidence that Mr. Bell is not competent?
No, Your Honor.
All right, sir, I'm going to find in all of your cases that you entered your pleas of guilty and true, freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of those pleas. And cause number 26, DCCR 0139, find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. Find all of those prior convictions that you pled true to true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then, excuse me, clause number 26, BCCR 0140, also find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find all of the prior convictions that you pled true to true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in clause number 26 DCCR 0274, again, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with previous convictions. find all of the previous convictions that you pled true, sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 3 of these cases will run concurrently, which means together at the same time. And I'm going to hand you in all 3 cases the trial court certifications that shows that these were agreements that I followed, and so you waived any right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Park. All right, good luck to you, sir. Thank you.
The courtroom is a cold altar. Jabar Bell, a man carved from bad decisions, stands before the bench. His voice is soft, robotic. Yes, ma'am. As he pleads guilty to theft of property with previous convictions, then again to a second theft, then again to evading arrest. Each indictment is a tombstone. Prior thefts from 2018, unauthorized use of a vehicle in 2019, burglary in 2023. He admits it all, freely, voluntarily, because he actually did what they charged. But the machinery of justice grinds imperfectly. In case 26 DCCR 0274, the evading charge, the indictment is incomplete. The prior convictions that elevate it to a felony are missing. The prosecutor stumbles. I didn't notice. A frantic negotiation follows. Dismiss, reset, amend by hand. The judge, impatient, orders a handwritten notice of enhancement. The defense waives review. And Jabar Bell, the man who ran from police, now waits in silence while the system rewrites his destiny on the fly. The judge returns. The amendment is granted. The priors are added. Unauthorized use, burglary. Bell pleads true again. He is sentenced to 4 years on each case, all running concurrently. He receives written warnings about firearms and loses his right to appeal. He nods. He thanks. He is led away. But the true suspense is not his guilt. It is how close he came to falling through a crack in the docket. One missing line, one unfiled motion, and the entire edifice could have collapsed. Jabar Bell will go to prison not because he was cunning, but because the court's clerical errors were caught in time. In the end, the most terrifying weapon is not a crime, it's a corrected typo.